We have read your briefs and we are ready to proceed when you are.
Thank you, Your Honor. May it please the court. Attorney Neil Agrawal for the defendant, Safaa Al-Zerjawi. You said it as best as I could, Your Honor. Your Honor, the facts of this case are not really in any real dispute, except for one, which I'll get to. My client back in 2007 entered a guilty plea to a whole number of charges. The judge gave him a sentence which everyone believed was a total of 12 years after determining which were concurrent, which were consecutive, and nobody appealed. The state did not appeal from that journal entry and the defendant didn't appeal. So everyone at that time was, I guess, satisfied with the 12-year sentence. In 2015, my client filed a motion for judicial release, this time with a different judge sitting than the one who sentenced him back in 2007. The judge denied the judicial release, which, again, he had a right to do, no problem there. However, the judge then issued a non-protunct journal entry modifying count 2, which was presumed to be concurrent and specifically said that it is to be run consecutive to count 1, which increases sentence from an additional 5 years from 12 years to 17 years. Now, the trial judge did this sua sponte. There was no motion by the defendant, no request by the state. It is unknown on what basis the judge made this modification. There's no transcripts prepared or noted. There was no notes. There was no hearing. There was no testimony. There was no witnesses. So nobody, it just came out of the blue, basically. My client never got served a copy of the notice until he found out about it later on. And then he asked this court for a delayed appeal from that, which this court granted. And that's what we're here before you today. Now, the first thing I want to argue, Your Honor, is the state is arguing that this appeal is completely untimely and that he should have appealed back in 2007 because a non-protunct refers back to the original entry. Now, I would agree with that in theory for the most part, but the problem is that my client and frankly the state had no problem with the original sentencing journal entry. The only issue is the non-protunct, which came out a number, 8 years later. I guess the state is making the strange argument that my client should have appealed back in 2007 from a future non-protunct nobody knew anything about. So I don't know what to make of that argument other than it's nonsensical to expect somebody to appeal something they didn't have a problem with on the grounds that in the future there may be a non-protunct, which nobody could have predicted 8 years into the future. Well, beyond that, there are only 2 ways for a trial court to modify a sentence once it's been lawfully imposed. One is if the sentence is a void sentence, or 2, if it's a non-protunct. Now, no one disputes that the sentence here is void. The court had jurisdiction, he entered a guilty plea with counsel, nobody appealed, the sentence was given. So it's not, you can't even say with a straight face that the sentence was void, it's not. Then the question is, was it a proper non-protunct? Now, the purpose of a non-protunct is to correct clerical errors, which are mechanical in nature, apparent on the record, which does not involve a legal decision or judgment. Now, changing a sentence from concurrent to consecutive, I would argue is not mechanical in nature, it is not apparent on the record, and it does involve a legal decision or judgment. Because one, if you're going to re-sentence him and increase the sentence 5 years, one, he had a right to be at the new sentencing hearing, which there was no sentencing hearing. 2, whether a trial court issues a decision concurrently or consecutively, it is a huge legal decision. It's not some tiny mechanical error that we're just changing the date or something of that nature. 3, it's not apparent on the face. When you look at the journal entry, count 2 is silent. It doesn't say consecutive, it doesn't say concurrent. And I cited case law that says if a trial court does not specify if it's concurrent or consecutive, it is to be treated as concurrent. And if it's ambiguous under the rule of lenity, that also favors the defendant that it should be concurrent. And in fact, there's nothing in the journal entry that says it should be held consecutive. Now, the state makes the argument by the fact that all these other counts were held concurrently, that meant the judge intended for count 2 to be consecutive. However, there's no way to make that leap. Did the judge just forget to issue count 2 and say consecutive or concurrent? I mean, it's missing. So we don't know by the absence of evidence why the state automatically wins that argument. I don't get that. So, this court has held multiple times in the past, once a court sentence begins, the court doesn't have jurisdiction to amend it. I know the Supreme Court said you don't even have to wait till a sentence begins. Once it's executed and journalized, it's final and cannot be changed except on appeal. So again, I don't understand the state's argument that somehow the trial court did it correctly in 15. And then when we get back to, then my client asked the trial court for a 9C appellate statement as part of this appeal, saying we need to know what did happen. The trial court issued a 9C journal entry basically saying the modification by the 2015 judge was accurate and it was based upon the true action of the 2007 judge. Now, where did that come from? What evidence did the judge rule on? The state didn't give any response other than saying the evidence speaks for itself. The defendant submitted an affidavit saying I was there at sentencing and the judge specifically said count 2 is to be run concurrently. There are no notes, no transcripts, no evidence, no other witnesses, no documents. There was nothing for the trial judge to hang on a 9C to somehow say that the 2019 or 15 judge got it right, saying that the 2007 judge, screwed up and not saying it one way or the other. So respectfully, Your Honor, and I cited 2 cases after I filed my brief that are almost directly on point that basically said the same thing. A nunc-pro-tunc is not, you cannot just change something unless it's apparent and it's clearly on its face that it's basically like a typo. Where in the 2007 journal entry is it a typo to say count 2 is to be run consecutive and added 5 years to a sentence? And again, if the state thought that was an issue, it was incumbent upon the state to appeal as much as it was my client. And if nobody appealed, then the journals, the prison officials thought from looking at the journal entry, it was 12 years. The trial court originally did, the state did. His out date was 12 years. And then in 2007, they added 5 years. And he's like, what? Where did that come from? So unless there's any questions, Your Honor, I really don't understand how this nunc-pro-tunc is proper, or that this court does not have jurisdiction to hear this appeal. So respectfully, I would ask the court to reverse the trial court and change the sentence back to the original 12-year sentence that was imposed by the 2007 judge. If there's no other questions, I have nothing else to say.
Thank you, counsel. Seeing none, the court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties from the clerk of courts, as well as posted on the Ohio Supreme Court website. We are adjourned until this coming Thursday, March 18th. Have a nice day. Thanks.
Thank you.
Thank you, Your Honors.